take for another form. I call Baba for 1GH. Message so when you subscribe to for 1GH, and message so be subscribe. No one like no share. No one turn on notification bell. So be update BI bell. On submit me account. I make out a comment section once you audio. Message so believe you comment me be a cost 101. And then some of the Bremo I the court ruling against speaker and as a parliament a senior lawyer. I didn't send be about to the papa and someone what can I say as in some manner. And I say idea the Supreme Court a day Bagbin episode can share a fast sound Newma and somewhere is no papa and some more chen say Parliament, Supreme Court, and nobody obey me a control Parliament. Until Nyamana and I even approach or move you in order to rule the Parliament, and answer Speaker Bagbin, and yet the rightful way to go. And Papa then some at to drag, she say, or squeezy. After your market, and then a pound for more day as some call court, no quite court no, a fast a rule as some. Mommy uncle and summer a rich at Tsikata at the two jana her condemnation in the best approach of the two jar. Papa Natchez or your nimi pa no nim the oye, and Tibaya after your market and some call back. No papa nature. Mommy uncle and some muncho money by Yakabia, yet best on
Supreme Court versus Parliament and the standoff. See a Supreme Court ne Parliament be omujana de I to say wenum kuta tomahawk wenum su kuta cruise missile obia to tunise. A senior legal luminary, Tsikata, has exposed the path of the Supreme Court ruling against Speaker Right Honorable Alpha for Bagbin's application. Lawyer Panic Kesi ora Tsikata. So the nsembia beto ho asansam no ne kwasam emu ohu pa na we bia nsembi so a ekokọ expose Supreme Court anamo a wonu mutu sabre na sen ena ora Tsikata odensam no totoye. Take a listen to him.
You know, the idea of asking for a stay of execution of a ruling of the speaker, there is really no legal basis for a stay of execution of a ruling of the speaker. That the court, the Supreme Court and other courts have the authority to stay execution of decisions within the court system.
Okay.
But you don't apply for a stay of execution of something that happens within another arm of government, which is the arm of the speaker. Now, the impression was given that because this is a matter for interpretation and so on, you know, the idea of asking for a stay of execution of a ruling of the speaker, there is really no legal basis for a stay of execution of a ruling of the speaker. That the court, the Supreme Court and other courts have the authority to stay execution of decisions within the court system.
Okay.
But you
now,
don't
he goes further to share yet another thought and set precedent to back his claim. Oka we na nso wasan ada sembi so edi. Now what say in law no ye say you need to set precedent. Precedent just say enime bi wo mu a esi da eno ne ye hwe so ne de ahwe se enne de esi no saa na no saa na ye enu nti won say ye wakase bia na ye ka twikase bia ka say na no say ene ye no enti say ya ye bi dade a na chese na akoye abakwasam, and that's exactly what Tsikata is trying to refer the Supreme Court to it this time around. Take a listen to him.
The Supreme Court, when it is faced with a matter in which somebody runs and says interpret,
right,
they don't automatically say there's an issue of interpretation.
Okay.
The court is guided by its own precedents,
right,
in which it talks about what qualifies
an interpretation
to invoke its exclusive power.
Okay.
And they make it also clear that other courts also have the responsibility to apply the Constitution. And of course, in applying it, they also do something that you can call interpretation. But when we talk about the exclusive jurisdiction, it is based on certain parameters. So here's one of the statements that was made in the Supreme Court in respect of the urban matter, for instance. the statement was made very clearly in the judgment of Justice Bagbin. He makes reference to another earlier decision of Chief Justice Archer, in which Chief Justice Archer, as he puts it, came out forcefully in support of separation of powers and the principle of non-justiciability of certain matters in these words. The Constitution gives the judiciary power to interpret and enforce the Constitution. And I do not think that this independence enables the Supreme Court to do what it likes by undertaking incursions into territory reserved for Parliament and the Executive. This court should not behave like an octopus, stretching its 8 tentacles here and there to grasp jurisdiction not constitutionally meant for it. So this was what one of the judges said. There are other statements in that case by other judges, all pointing to the fact that the Supreme Court should be careful in not venturing into the territory of others. Now, so when the Supreme Court, without even giving notice to the Speaker, so that the Speaker can at least let his side of the matter be heard, when it does that, it's very problematic. And the Supreme Court, again, has itself said that when there are previous decisions, it has to go by them, because that's what the Constitution provides. Article 1293 of the Constitution. There again, very clear. The Supreme Court is bound by its own previous decisions. Unless it wants to depart by stated reasons, then it can do so. But here, the court did not even make reference to any of these previous decisions because, frankly, they did not give the Speaker a chance to put before them his side of the case. So based on Honorable Afenyo-Markin's ex parte application, as we call it, they made those pronouncements about the orders. Now, those orders are also very problematic, because when you look at the writ that Honorable Afenyo-Markin put to the Supreme Court, he wanted an interpretation of 97(1)(g). You talked about G and H, but in his writ, he actually did not say G and H. He said G.
Right.
So H, which is about Honorable Esiama, the Deputy Speaker, was not part of what he took before the Supreme Court. People lose sight of that.
Right.
Now, so if he took G to the Supreme Court, the Supreme Court had no basis for bringing in orders in relation to H.
Right.
Because that's not part of the writ. Additionally, as I think was pointed out by counsel for the Speaker when he tried to set aside the writ, you have a situation where the papers that were filed by Honorable Afenyo-Markin were deficient in terms of the rules of the Supreme Court itself, because the rules of the Supreme Court required Honorable Afenyo-Markin to have an affidavit that supports, verifies the statement of case that he filed, because an affidavit involves somebody stating on oath certain facts, and on that basis the court can act. In this case, there was no affidavit. So all that was in the statement of case lacked verification. And essentially, when the Supreme Court in its ruling was talking about things like constitutional crisis and so on and so forth, it was relying on things in Honorable Afenyo-Markin's statement of case which had not been verified. And therefore, they could not be relied upon as evidence before the Supreme Court. And when you have clear rules which require that for such an originating process, you must have an affidavit. Again, there is judicial precedent for insisting that in those circumstances, the proceedings are void.
Right.
So they should not have proceeded without at least taking account of the fact that there was a deficiency in terms of compliance with their own rules. So that again is a problem. As I said, there are multiple reasons.
But let me, forgive me for taking you back just a little bit. You talk about invoking the exclusive jurisdiction of the Supreme Court to interpret certain clauses in the Constitution. Are you saying, with the precedents that you give out, that even in this matter, that jurisdiction had not been invoked?
It had not been properly invoked by Honorable Akroma writ before the Supreme Court.
Okay, so then takes me back to the question that I asked you earlier. What would you have had them do?
What would the Supreme...
What would you have had Akroma, for instance, and the Speaker do?
First of all, the Supreme Court, I believe in this context, using its own rules, should have pointed out to Honorable Akroma that there was no affidavit verifying the statement of case that he had filed before them. And therefore, his writ was deficient. And they could not proceed on a deficient writ. I think that would have been a simple end to the matter. Secondly, if the Supreme Court wanted to give any guidance to a plaintiff who has not complied with the rules, they would, again, just refer them to the rules and give them the opportunity, if they thought appropriate, to correct those. Because, again, the rules of the Supreme Court will make it clear that non-compliance shall be a bar to further proceedings unless the Supreme Court waives that. There's nothing in the record which tells us that the Supreme Court waived anything by way of, sort of dealing with a non-compliance that there was, just on the face of things. So then the reason all these things are important is not just because of technicalities. The reason these things are important is because the rules enable us to ensure that things are done properly in an orderly fashion, and that whatever then comes authoritatively as a pronouncement of the Supreme Court is an appropriate authoritative decision that we can all go by. But where we see so many errors in terms of how the proceedings have gone, it just undermines the authority of the Supreme Court. And this is really important because, again, as I said earlier, all of us have a responsibility to respect the Constitution and to ensure its enforcement. So, for instance, if you go to Article 3 of that very Constitution, it makes it quite clear that if any attempt is made to go against the Constitution, we all have a duty to resist it. And that attempt can be made not just by people wearing military uniforms, it can be made by people wearing wigs and gowns as well. So we really have to take seriously our responsibility, all of us, to be familiar with what the Constitution provides. The Constitution is not just some arcane set of words that lawyers can, indulge in and that judges can make pronouncements of. The Constitution, is the supreme law of the land, and it's very clear in the Constitution, for instance, that the exercise of that judicial authority itself is on account of the sovereign will of the people, which is embedded in that Constitution. So these are really serious matters, and I think that it is sometimes too simplistic for people to give the impression that the Supreme Court has made a statement and therefore, you have to go by it before you complain and so on and so forth. In this particular case, as you know, the Speaker actually took the opportunity of having his counsel go and try to set it aside.
Great, folks. So, Ushebebia, Ora, Tsatsu di free or diabeya. Wama a breakdown, very comprehensive breakdown. Kwanya, say, afenyoma kinode, asem nodefa. The role say Supreme Court, wamoto tunyamafa. But we, assembly na kwaya to say, yemuni nengu, because, asem we on, maka. Enye bibiye hu sao, no. Eya bribi na aba na NPP for nim say they are shortening their numbers, their majority. Yempel. One with the Supreme Court, say ba aba I say caterpillar ye di romnie bunyome guni afa ye we ni akwa no anum just me say one day will come we'll revisit this issue more ye Ghana mo be hu say me kai now Tsikata can say no. He again cited the powers also vested in the Speaker by the Constitution and therefore can cite the Supreme Court judges also for contempt of Parliament. Tsikata face ho or say Speaker no subet ya cite judges no motiti ono womoso for them contempt of Parliament. So more being an address oh after Supreme Court there Parliament is also an autonomous body. Parliament is a master of the rules and the game. Take a listen to Tsikata.
No, when you say that someone is talking about taking the Speaker to court for contempt and so on and so forth, you know the Speaker also has within the Constitution the power to hold people up for contempt of Parliament. So, are we going to find ourselves in a situation where the Speaker is also going to have powers to commit for contempt, and the Speaker also uses or tries to use those powers? I don't think it helps anybody to have what you rightly called, a kind of power battle where everybody is trying to stand on their, sort of high horse. Because ultimately, when you do that, the country suffers, and frankly, I think your own reputation suffers. And I want to give an example of the way that the reputation of courts can suffer.
And say, what we say, Constitution one year provisions in Kwama, only the Supreme Court. No, the Constitution also makes provision for the Speaker. As long as Amabeka Sasim we pense, even Parliament Committee BR Oko transfer, Parliamentary Committee BR, so that committee automatically is like a high court. And that committee can cite you for contempt of Parliament. Oh, yes. What about the Speaker? It's more being an payment a senior lawyer be Akroma, warrior analysis be radio, so Ayora Kofi Bentel. Now, Kofi Benson, not some what can I say? The Supreme Court has spoken, and that just say, madina is so for Supreme Court there. Just say, sisi asuo, bie neo, edem. As long as Supreme Court back Supreme Court ne kasa, possibility said two things may happen. Either we catch cold or we go to bed. How? The law was made by man or man made by the law. Which one? How? It is idea Supreme Court here, if it is not in consonance with the practices of law, should we just accept that it is a Supreme Court? It is Supreme Court to say, and ne, was sorry, Abetra say Ghana for, was Shemra say yenda 6 o'clock. We just have to abide by this. I mean, where, how? What logic is in this? And Kofi Benson went further to say, as long as the likes of Cynthia Morrison and Trokrata and Femba so ma resign, now Supreme Court ebe declares so Parliament and your business. That is all about it. And I'm saying, how? But then again, listen to Supreme Court for, and then just say Supreme Court, Mokache NPP say, go and amend your party's constitution, Article 3, Article 9, which says, anybody, Biara Ube take such a position. The laws of the party says there, automatically you forfeit your membership. As they see, the likes of Cynthia Morrison and Nipa Mienu, Womuja Henfa. Just say, I deal with a small logical. Now, so NPP for no lose a majority of your honey, and I'm way. Other than that, Munim said they are more. Because all speakers from Abena and to Tom Ranasaram said that, and I some way soon copy baby aso sada. Why are you doing this?
Senior lawyer statute HSA. Even the filing process now NPP for member of parliament NPP for more parliament at the court. That is not the proper way of proceeding this case to the court. And it says a more penny best way to solve this one. Markings and file with the proper procedure in order to ascend this case to court no for the proper procedure and ruling na some no more can say court no Supreme Court account fine another. It is never done that way because Parliament Yura Bagbin ono so ekura ni own supremacy ono so de ye adwuma ye magana mra na o de ye adwuma nto mu ntimi me hya ne keten enche ne de onye da bida but if say e bi asida na ye hwe so de aye then for only problem bia on because there was some precedents ye follow ye be done ye na we dey asam na ekoso but if say the things what they are doing afenyoma kene ne call for doing said the more you're right and therefore they should change their constitution. NPP for should change their constitution rules our mother band yes adia and ye be any honoma a BC Akroma. Now make us a high Alpha OneTV message so when subscribe here message or subscribe no like no share no turn on notification bell on sabe update be on sabe to me aka now make us a comment section once you audio message so believe you comment be a one Akroma.